This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Madam Clerk, and good afternoon. This is our, I believe it's our final case of the day today, November session of the Court of Criminal Appeals here in the middle section in Nashville. My name's Robert Wiedemeyer. My colleagues are Judge Holloway from Columbia and Judge Dyer from Memphis. We are obviously utilizing Zoom for these oral arguments, and that's been a great benefit to us during the pandemic. And that being said, we are all looking forward a great deal to getting back into the actual courtroom. We've read the briefs. Both of these attorneys have been here numerous times, so you know the rules, 20 minutes per side. I think that's all the preliminary matters I need to address. Madam Clerk, anything else you think of we need to discuss before we start on the case?
No, Your Honor.
All right, if you'll call the next case, please, we'll proceed.
State of Tennessee versus Leavy L. Johnson.
Your Honors, good afternoon. I'm Ben Russ. I represent Mr. Johnson. I'd like to reserve 5 minutes of rebuttal time, please. Thank you, Judge. The first issue that I had planned on addressing this afternoon was Mr. Johnson's sentencing. Of course, Mr. Johnson was convicted of the offense of rape, and despite the seriousness of that offense, of course, the General Assembly has permitted under certain circumstances for a probationary sentence for conviction of rape. And that was obviously what Mr. Johnson would requested from the trial court during his sentencing. The trial court ultimately sentenced him to the minimum sentence possible of 8 years, but it was in confinement. And I think that the trial court erred in this for numerous reasons. Primarily, Mr. Johnson presented what I would call, perhaps if there is such a thing, and again, it's difficult to make this argument without sounding callous about the offense that he was convicted of. But if there was a candidate that deserved to have a chance at community release, I think it would be someone like Mr. Johnson. He had, at the time of his conviction, it was in his mid to late 30s. He has a relatively minor prior record, a felony theft offense. There's nothing violent in his record. There's nothing otherwise sexually related in his record. He had a psychosexual evaluation, of course, which is mandated by the court. And I've noted this issue in my brief. He was assessed as a low to moderate risk. I don't begin to really know or understand how the psychologists come up with their risk assessment point evaluation. And I only go through this exercise for the specific purpose. He was assessed an additional point in his assessment for having had his sentencing hearing continued multiple times. I have no idea why that would impact his risk of reoffending or not. However, that particular point bumped him from the low end risk assessment to the moderate low end. So without belaboring the point too much, if he had not had that particular point, he would have been on the low end of the assessment of reoffending. And, he has a strong family history, a strong support system. His daughter, his mother, both provided testimony at the sentencing hearing itself. And, I certainly could understand how a sentencing court can look at this and look at the sentencing principles. And ultimately what this court, the sentencing court, hung its hat on was that it didn't want to depreciate the seriousness of the offense. And if a sentencing court is looking at someone who might be a good candidate, perhaps for a release like Mr. Johnson, and says, well, I don't think that I could justify giving him no time in confinement for an offense like this, I would understand that entirely. In fact, I was his attorney at sentencing and had made the same argument to the sentencing court. However, Mr. Johnson at the time had served approximately a year and a half in confinement based on a rather lengthy period of time before he was able to make bond. And then he was taken into custody at some point after his conviction. So at the time of sentencing, he'd already done almost a year and a half in confinement. And so ultimately, I think that if Mr. Johnson, having served a year to a year and a half in jail, presenting the sentencing court with someone who is at the older range of people who offend in this manner, in his mid to late 30s, has a low risk assessment to reoffend, has no significant prior criminal record, has strong family support. If he's not a candidate for probation, even on a rape, I don't really understand why the General Assembly makes it possible for someone to get probation on a rape offense, because I don't know who they would pick. It seems a little like fool's gold, to be quite honest. So I think that given all of those things, Mr. Johnson presented an excellent candidate for community release. The sentencing court was very sparse in its ruling, said essentially, as I said just a moment ago, in order not to depreciate the seriousness of the offense, I think confinement is necessary. While that notes that the court considered what the guidelines and the principles were, I think it shouldn't be used as a catch-all to simply say, I'm going to do this, and here are the magic words that I need to say. It doesn't.
That basically what our Supreme Court has told us?
Well,
I mean,
I think the court, to sort of look behind the ruling, the court says that the sentencing court shall consider the sentencing principles and shall consider what the General Assembly has offered as guidance in sentencing. I think it probably requires a little more to demonstrate the court has actually done that than simply parroting what the statute says.
But that's what I mean. I'm not disagreeing with you as much as I'm just pointing out that that's basically what our Supreme Court has told us, though. In Bice and the following cases is that, if they say they followed the guidelines, then there's a presumption that it's hard for this court to go behind that presumption. I understand your argument, but in one sense, there are magic words, and the magic words are, I am considering the purposes and principles of sentencing, and I find that, to allow probation would be to depreciate the seriousness of this offense, and kind of once those magic words are spoken, as long as there's something in the record, and there is something in this record based on the briefs, I don't know what we can really do.
Well, I would respectfully agree with you in part and disagree in part. I agree that that's the guidance that has been offered by the Supreme Court. I would disagree that the Supreme Court's expectation of trial courts and sentencing courts is to simply, have some sort of incantation of whatever the sentencing principle is, and then do something that is totally divorced from whatever has been presented to the sentencing court, and simply saying those words doesn't solve over that. That would be my opinion. And I think that kind of is here. Not to argue against myself necessarily, but if the sentencing court had gone on to cite the reasons why it felt depreciation of the offense was going to happen if he got probation, that might have put this in a different light. The sentencing court says basically nothing. Let
me phrase my question a different way then, because you said something that made me think of this. Your statement was, well, I don't think that's what the court meant, or that's what the court was trying to say. But my point is, that's what they've said. So as far as the intermediate appellate court, what can we do until they actually come out and say, hey, you actually have to say more than the magic words?
What can this court do to answer your question, Border? I mean, I think this court can determine that the sentencing court has abused its discretion. Obviously that's a difficult burden for me to meet on any level, for any particular issue.
Based on the Supreme Court's opinions, based on what this trial court said, there's a presumption of reasonableness. We can't get to the abuse of discretion question. I'm not saying you're wrong. I'm just saying, I want you to understand the bind we're kind of in, just like the binds you're in. If there's more direction needed by the Supreme Court, we're not the court to make it. They're the court to make it, I guess is my point to you.
Well, I understand the position intermediate courts are in with regard to this. Well, again, I think a presumption of reasonableness is still fashioned on the basis that it is reasonable based on the facts and the evidence that's presented to the sentencing court. And I would and of course the necessity of the sentencing court to explain its sentence, I would say that, procedurally, I don't find that personally adequate to simply say, I've considered the sentencing principles, and in order to not to depreciate the severity, I'm going to sentence him to confinement. I think that more is required to demonstrate the reasonableness of that sentence, and not simply in this particular circumstance. So obviously I'm advocating for Mr. Johnson. So again, yes, you're correct, Judge Dyer, about the standard. However, I don't think, I think a standard of reasonableness still has to be met. And I would respectfully say that I don't think that's been done here. Simply because, the entire course of the proof. I mean, again, if Mr. Johnson isn't some candidate for this, then who is? So I would not necessarily say. I mean, I would say it's not reasonable on the sentencing court's part to simply overlook everything that's in Mr. Johnson's favor and say. I mean, again, that sort of, to argue the other way around, makes the sentencing court in a position that nobody coming in front of it could possibly get this if it couldn't be someone like him. So,
well, let me just say, from a factual standpoint, I mean, you have an employee working at a business that takes a customer and tells the customer he can do something for her, get her to the backstage or whatever else, if she'll do something for him, according to him. And then he takes and has sexual relations with her, which she says is rape, which apparently the trier of fact thought it was. And so now we're at sentencing, and he's a qualified individual for probation, but he's certainly not necessarily one that's favorable. The trial court doesn't have to make a presumption that he's a favorable candidate anymore. All he has to do is find factors that justify denying probation. And isn't that what the trial court did with some of his findings?
Well, I didn't see the findings at trial or the findings at sentencing.
Sentencing, sorry.
The trial court didn't make a ton of findings at sentencing. I think the question, if I phrase it a little bit differently, does he have to be remorseful and admit guilt in order to get probation? I don't think that's necessary. No. I don't think that's necessary, and I don't think it necessarily makes him an unfavorable candidate. On a practical level and a human level, would it be a more compelling person that a sentencing court would consider more strongly? Yes, I believe so. But I don't think on a legal basis it's required that he admit guilt and be remorseful to be a favorable candidate for probation. If that answers your question, or maybe I'm answering a different question.
Well, I wasn't really talking about admitting guilt. I'm just talking about the facts of the case. That you tried to compare him to any other rape defendant, and I think there are facts in this case that separate him from a lot of the rape cases. Two people are on a date or something like that, and it's alleged that one person raped the other. It's a little bit different factual situation from this, where he's working at Bridgestone Arena, and
that's correct.
Takes a customer back behind curtains and allegedly rapes her based on the conviction. That's what I was trying to say, and it's not factually similar to a lot of other rapes that I understood your argument. Say this is like, these other cases where they're.
Well, respectfully, I don't personally have a lot of date rape cases. Most of the rape cases I've handled, I find the facts to be more egregious than this by quite a long shot. But I'm not debating that there could be a less serious situation. That's true. That more or less leads me to my next argument about the sufficiency of the evidence here. Essentially, Mr. Johnson and the alleged victim agree on almost everything that happened here, except for the consensualness of the sex. It was somewhat back and forth on the testimony between her and her friend as to whether she had agreed to perform whatever was going to be done in order to get backstage or not. But she certainly agreed to go with him to whatever area of the arena they ultimately ended up in. There was certainly a discussion before they went back there about exchange of some kind. The question was simply whether she agreed to it or not. And then, of course, Mr. Johnson never denied that they had sexual relations.
That's a credibility question.
Correct. Yes, it is a credibility question. And I would say, this is pretty much a classic he said, she said situation. In a he said, she said situation, there's sort of four outcomes that a trier of fact can look at. If they believe both of the people, they think that he was acting without the intent. He believed that he had consent from her for whatever reason, then he wouldn't be guilty, even if they believed her version of the facts as well. If the trier of fact believed neither of them, then the state would not have met their burden by not presenting credible proof that any kind of sexual penetration had even happened. Of course, if the trier of fact believed Mr. Johnson and didn't believe the alleged victim, he would be not guilty. The only scenario that permits him to be convicted in this kind of situation is if the victim is believed by the trier of fact and Mr. Johnson is entirely disbelieved by the trier of fact. Given the way the proof stacked up, again, he didn't deny that any of these things happened. I think it's debatable that he fled the scene afterwards, but I won't get into all that. But more importantly, it was she gave a description of the victim immediately. The victim gave a description of the suspect immediately afterwards that was far different than Mr. Johnson. Although she eventually changed what she said even prior to trial. And then also, it was uncontroverted that she consumed a decent amount of alcohol. It was a little bit back and forth about how much she consumed, but she was impeached at trial with her intoxication at the very least. So you have the impeached testimony of the alleged victim. You have Mr. Johnson testifying at trial that, yes, everything happened except she was willing to do it instead of saying after the fact that she was unwilling. So I understand what's required under the sufficiency standard, but I would say that the trier of fact here is in error in finding that Mr. Johnson is entirely unbelievable and the alleged victim is entirely believable, because if the trier of fact even has a reasonable doubt as to whether Mr. Johnson's telling the truth, the judge should have found him not guilty. So I would respectfully say that was error as well. That is more or less all the argument I have. Unless there's any questions further, I just reserve the rest of my time for rebuttal.
All right. You still have 5 minutes for rebuttal, Mr. Russ. Thank you. General, you ready?
Yes, Your Honors. Good afternoon again. Austin Watkins here on behalf of the state of Tennessee. The defendant's conviction should be affirmed because the victim's testimony was sufficient evidence of guilt, and the defendant's 8-year sentence to serve should be affirmed because the trial court didn't abuse its discretion when denying alternative sentencing. Your Honors, if it's okay, we'll discuss the issues in the reverse order, and we'll start with the sufficiency. And in this case, as Mr. Russ acknowledges, the only question was consent. I mean, that was what the case was about. But the victim's testimony that she did not consent to sexual intercourse with the defendant was legally sufficient evidence to support the jury's verdict. Tennessee Supreme Court and this court routinely follows the rule that a victim's testimony in and of itself can be legally sufficient evidence. For that testimony to be so deficient from a constitutional standpoint that it cannot support a conviction, to fail that Jackson standard, the Supreme Court has basically said it has to be patently unbelievable. Like no rational trier of fact could have chosen to accept the victim's testimony. And that is nowhere near what we've got here. There were some inconsistencies in her statements to people after the encounter happened, but she was very consistent about the issue of consent. So there were some differences in how intoxicated she was, about her descriptions of who the defendant was, but he admits that he's the guy, and she was consistent in telling everyone that this was either some version of a sexual assault or a rape, in the sense that this was against her will, that she was consistent in testifying to that. And on top of it, Your Honors, it's not just a pure he said, she said. What we do have that corroborates her testimony is that multiple witnesses saw her in a traumatic, emotional state. The alcohol control officer saw her leaving the curtained area immediately afterward. So this isn't even like some time removed. We've got witnesses immediately after this encounter going, this did not look like someone who had just experienced a consensual encounter who had maybe changed her mind, right? And so the jury is entitled to hear all of this proof. This is a quintessential credibility determination. and essentially say, you know what, we believe her and we don't believe him. And so that is all that's required under sufficiency review here by the constitutional standards set forth in Jackson versus Virginia. And so the state would ask you to affirm on sufficiency grounds, Your Honors.
Is this the case? And of course, we've got a lot of cases, read a lot of briefs. But this is the one. Didn't she have some bruises on her knees or something else where she allegedly was pushed down or forced down in this room? Was there proof of that?
Your Honor, I don't recall there being a specific, verifiable proof of injury. She testified that she'd hurt her elbow, that her phone was shattered, but I think that was all still testimony. I think that the only thing that I can point to that was kind of corroborated by someone other than her was something that either they had witnessed her demeanor or she had told them in, for example, the medical kind of interview when she got to the hospital. I think she talked about her injuries. I think she told one or both of the officers about, being hit from behind and falling down and hurting herself, kind of hitting a chair on the way down one of the seats in the arena. So I don't think there was documented proof of a bruise or an injury, Your Honor. But on sufficiency, on sentencing, Your Honors, the trial court properly exercised its discretion and it imposed a minimum sentence within the range, but it did choose to order it to be served in confinement. So this wasn't a situation where the trial court kind of, without adequate explanation, threw the book at the defendant. Admittedly, Your Honors, this was a bare bones sentencing ruling. The transcript is pretty clear that it is about a page and a half long. But what is clear from the trial court's, findings on the record is that it heard testimony at the sentencing hearing, and it said that it was considering that proof, and it said specifically that it was considering the mitigating evidence and the enhancement factors argued for by the state. It said specifically that it was considering the impact that incarceration for the defendant, the effect of kind of this situation was having on the defendant's family. And so it chose to give him that minimum sentence. And then it said, you know what, but I do find that confinement is necessary based on statutory language, necessary to avoid depreciating the seriousness of the offense and to provide an effective deterrence. And so, as Judge Dyer has pointed out, this is the state of sentencing law in Tennessee, that if a trial court, it can kind of get some of it wrong. It can misapply enhancement factors when we're talking about where the sentence should be within the range. And here, the trial court got the law right. It is acknowledging, everything that it's supposed to be doing. It said it, although it could have provided more insight or more, explanation about why it did what it did. But it made it clear. I am the person who's in this room. I've heard these witnesses. I've heard the testimony at this trial, and it was a bench trial. This judge decided guilt. And said, I think that this is what is appropriate in this situation, and Byes, and in this case, Caudle, which applies the Byes presumption to alternative sentencing determinations. That's enough, and that this court has to defer to the determination of the trial court in this situation. And Your Honors, there is enough in the record to support that determination. I mean, this isn't just kind of an off the wall decision here. We have, as has kind of been discussed, a particularly concerning rape in that it happened in a situation where this defendant used his status as an employee in a particular location where he manipulated his kind of position of authority to his advantage. He secluded this victim from her companion, who was initially available to or present and talking and engaging with this defendant. He took her into a portion where there were no cameras, and he probably knew that of this arena. And he probably knew that this defendant was vulnerable because she was impaired. And so he took advantage of that situation. He showed no remorse. And so not that that is dispositive in itself, but it's a drop that goes in the buckets. And then, Your Honors, on us, separate from this finding for depreciating the offense and effective deterrence, a separate basis is essentially that manner or kind of alternative sentencing has proven ineffective in the past. And what the record shows is that he had violated probation for an offense out of state. And so it's really just not unreasonable for a trial court to go, look, you've tried this before and were able to unable to abide by the conditions of an alternative sentence, and I'm just not going to give you that advantage here. Now, to be clear, the trial court didn't explain it that thoroughly on the record. That's me, explaining why, though it is a reasonable decision. But under this very deferential standard of review, Your Honors, that's enough. And so you heard me talk 3 times today, so I will try not to get you too tired with my voice because you're going to have to hear me twice tomorrow. But if there are any questions of factual law, I'm happy to address those. Otherwise, Your Honors, the state would ask you to affirm the judgment because there is sufficient evidence, and it would ask you to affirm the sentence because the trial court's findings are supported by the record. Thank you, Your Honors.
Yeah, thank you, General. Mr. Russ, you've got your 5 minutes of rebuttal.
I'll just make a few very brief points. General Judge Holloway, you asked the alleged victim. She said she'd injured her elbow, but I'm not sure if this was the case you were thinking of or not. But she did not have any extensive injuries based on this encounter. As the Attorney General said, yes, it is accurate that Mr. Johnson had a probation violation in a previous case, but that was not the reason that the court used in order to give him a sentence of confinement, nor was it even alluded to in the court's ruling. Lastly, one point that I will make, and I made it the first time around, but the alleged victim consistently maintained that she was not intoxicated, even when she was confronted with her toxicology report from her medical attention that she received afterwards. And so, that is why that impeachment matters. It's not in order to trust that her story on the consent is accurate, you also have to look at whether or not she was intoxicated. If she's being led astray by Mr. Johnson in order to take advantage of her, it's hard to have it both ways. Either she's with it and she's able to say no and everything that she said and recall, or she isn't able to do those things quite as accurately because he's somehow taking advantage of her. So I don't think the proof bears both of those things out. I'll leave it to the court. But she consistently denied that she was intoxicated, but that seems to be inaccurate. So if there are no other questions, that's everything I have this afternoon.
All right. Thank you, Mr. Russ and General Watkins. Excellent arguments, excellent briefs. We'll take the case under advisement, and we'll be in recess till tomorrow at 9 o'clock, I believe.
This Honorable Court of Criminal Appeals is in recess until 9 a.m. tomorrow morning.